All right. Good morning, everybody. We are on live stream here on YouTube. Court will begin with the April 13, 2022 docket. And let me start bringing in some attorneys and their clients so we may proceed.
Number one.
Ms. Del Bosque, can you hear me? Okay. Is he
Papa
there?
Saldua did the social study.
Okay, so he's there. Okay.
I just need the name of the parents.
Out of the parent witness, right?
Yes.
Okay. Maybe Paul knows.
I think Rolando Cantu has an announcement on that.
You want to bring him in right now on the Rule 11? Yeah, bring him in.
Judge, was there a question? I didn't hear the question.
Yes, Paul. Who's the witness or who's the parent in your case?
This is a case with Cynthia Del Bosque,
Right?
and the parents are the Ovalle family.
Oh, Valle. Okay, thank you.
Jose Ovalle.
Okay, Ovaya, thank you so much. We'll get you in. We'll proceed in a little while. Mr. Cantu, good morning, sir.
He's muted.
Good morning, Your Honor.
Yes, sir. Good morning. I think you're here on CL 20-4492D, right? McAfee.
That's correct, Your Honor. And there was a Rule 11 agreement that was filed. I agree. I'm in agreement with it. I just wanted to make sure that the court's okay with it.
We got it.
Okay, so
We're okay. Thank you so much.
I have nothing further, sir. May I be excused?
You're excused. Have a great day, sir.
Happy Easter, sir. Bye-bye.
Happy Easter. Bye-bye.
Okay.
Okay, there's Miss Del Bosque.
Good morning, Judge. I'm sorry. I got kicked out for some reason.
Oh, no problem. It wasn't me.
No, it wasn't. I think it's my.
I think we have Mr. Paul Basaldua, and I think, is it the Ovaya family?
Yes.
The parents or one of the parents?
Yes. It's Dovaya is the adoptive father, and Rebecca Mayorga is the mother.
Okay, and they're probably together, right?
Probably, Judge. I'm not sure.
Okay, and I don't see. There's Mayorga right there.
Okay.
All right, maybe they're together. And Rebecca Mayorga, there she is. And she needs to unmute.
Oh, yes, I'm here.
All right, good morning.
Morning.
Good morning, ma'am. You're Rebecca Mayorga, right? And with you, is it Mr. Ovalle?
Yes.
Okay.
You guys need to speak up, please.
Yes, speak out a little bit loud so we can hear you. And of course, the court reporter needs to hear everybody. So everything can be recorded here. And Ms. Del Bosque, I think we have everyone because Mr. Basaldua is the person who did the study.
Yes, Your Honor. Edna Cedillo is the guardian ad litem for the child, and Alejandro Munoz is the ad litem for the unknown father. They've both signed off on the order.
Okay. All right. We don't see him in the
Mr.
waiting room.
Munoz is here.
Oh, Mr. Munoz is there, but I don't see Ms. Cedillo. So let me bring him in. And we're here on A0018-21-4 in the interest of Micah Alexander Science.
Good morning, Your
All right,
Honor.
there's Mr. Munoz.
Good morning, Judge.
All right, good morning. So, and there's Mr. Basaldua right there. Ms. Del Bosque, your first witness? Who do you want to call?
Yes, Your Honor. Let me call Ms. Mayorga.
Okay, good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down and listen carefully to the questions. Ms. Del Bosque, you may proceed.
Your Honor, before I proceed with her examination, I'd ask the court to take judicial notice of all documents on file.
Court will hereby take judicial notice of the entire file in cause number A0018-21-4 in the interest of Micah Alexander, a child. Okay?
Thank you, Your Honor. With regard to the termination first, Your Honor, Ms. Mayorga, can you please state your name for the record?
Rebecca Lynn Mayorga.
Okay, and Mayorga for the record is spelled Mayorga. Is that right?
Yes,
And Ms. Mayorga, you're the biological mother of the child named Micah, Micah, Alexander Signs. Is that correct?
yes,
And Micah Signs' date of birth is August 31st, 2017, and he's a male. Is that right?
yes,
And the biological father to Micah Signs is Ryan Nathan Signs, correct?
yes,
And Mr. Signs has executed an irrevocable waiver of parental rights. Is that right?
yes,
And it's called an affidavit of relinquishment of parental rights, correct?
yes.
Now, has Mr. Signs had any contact with Micah Signs during his life?
Just like once or twice within like a week when he was like 3 months.
Okay, and how old is Micah now?
He's 4.
Okay, and you understand that there was that Mr. Signs had not been adjudicated as the father of Micah, is that right?
Yes,
And therefore the court appointed Mr. Alejandro Munoz as the ad litem, sure that there isn't any other father out there claiming to be Micah's father, is that right?
yes,
Okay, and as far as you understand, there isn't anyone claiming to be his biological father.
no.
Okay, Judge, I pass the witness.
Okay, Mr. Munoz?
Judge, I don't have any questions, Judge. I was appointed the ad litem for the unknown fathers, Judge. And
Okay,
no questions, Judge.
all right. Ms. Del Bosque?
Judge, I don't have any further questions except that Ms. Mayor court to terminate the parental rights between Ryan Nathan Signs and the child Micah Alexander Signs. Is that correct?
Yes,
Nothing further as far as the termination goes, Judge.
All right, court so orders. Court will hereby terminate the parental child relationship between Ryan Nathan Science and Micah Alexander Science.
Thank
All right,
you.
you may proceed, ma'am.
I'll proceed as to the adoption. Ms. Mayorga, you are currently married to,
Jose Luis Dovale.
very good, and Mr. Jose Luis Dovale has resided with your son, Micah Alexander Signs, for more than 6 months.
Yes,
And there has been an adoption evaluation performed by Paul Bazaldua, correct?
yes, ma'am.
Additionally, Mr. Dovale has also provided us with his criminal history record, correct?
Yes,
And the child, Micah Alexander Signs, is a U.S. citizen, correct?
yes,
And you're asking that the adoption by Jose Luis Dovale of Micah Alexander Signs be granted. Is that correct?
yes.
All right, nothing further, Your Honor. I pass this witness.
All right, Mr. Munoz?
No questions, Judge.
All right.
Your Honor, and just for the court's information, the order granting the termination and the adoption is on file. It was filed this morning. It had been rejected yesterday by the clerk. So that is on file. That's been signed by both Mr. Alejandro Munoz, who's the ad litem for the unknown father, and by Edna Cedillo, who's the ad litem for the child, and by myself, Your Honor.
Okay, and the social study has been made part of the record, right?
My understanding is, Judge, is that had been filed previously. It had been
Okay,
rejected by the clerk, but that Mr. Bazaldua is in the process of refiling it.
okay, he's gonna refile it. Oh, okay. Anything else, Mr. Basaldua? Any questions, anything?
Judge, I just want to express that it was an honor to be part of this adoption. I got to know Rebecca and Jose pretty well via Zoom. We had many conferences I sent Mr. Duvaya a questionnaire concerning. I was a little concerned because of the age of the parents, but Mr. Duvaya has shown that he's well involved with the child since he has been residing with Rebecca, involved with school and with medical appointments and things of that nature. And he also has displayed to me that he has a very good understanding of the long-term commitment that an adoption, whether him and Rebecca continue in the relationship, Micah will still be his son. And he very proudly accepts that. And I like to say, Judge, that in my report, I recommend 100% the adoption. And so does my dog, Fritz.
Okay. All right. Well, thank you, Mr. Osaldua. I'm glad. Thank you for your report. Okay, sir.
Judge,
Yes.
just for the record, Judge, for the unknown father, I concluded my research. I didn't find anyone.
Okay.
And as for Mr. Sines, Judge, I tried to make contact with him to know.
Okay. All right. Thank you, Mr. Munoz. All right. Court will hereby go ahead and approve the adoption of Micah Alexander Sines by Jose Luis Dobaye. And how about a name change?
Yes, Your Honor, we are asking for a name change for the child from Micah Alexander Sines to Micah Alexander Dovale.
Dovale, okay.
And that spelling for the record is capital V-A-L-E.
D-A. Okay. Okay. Did everybody, were everybody paid their expenses as well? Is that being taken care of?
Yes, Your Honor.
Yes, Judge.
Okay, okay. Let me see here. Well, I think that's going to wrap it up. Congratulations, Mr. Dovale and Ms. Mayorga.
Thank you.
It should be a real happy day today. And so not too often do we have adoptions, and I wish we could have more of them. But this is one of those days that we're all going to enjoy. So you are excused. You'll have a great day. Court will approve all remedy that you have asked here in court, and we'll sign an order hopefully today, this afternoon. All right.
Congratulations.
Thank you
Thank
so
you,
much.
Judge. Have a great day.
All right.
And
Y'all make
congratulations
the
to
excuse.
the
Thank you very
wife.
much. Bye-bye.
Have a wonderful
Bye-bye.
week.
All
Have a
right. Thank you.
holy week.
Bye-bye. Bye-bye.
Mr. Salinas, number 9, his client, and Lisa Morin.
Okay,
or Liza Morin,
Mr. Rick Salinas. Let me see here. Number 9. There he is. And Liza. Is it Liza Maria Morin, right? All right. Miss Morin, you need to unmute.
Ok, estoy lista.
Okay.
Okay, I'm ready.
Okay, good morning,
Buenos
ma'am.
días.
Yes.
And Mr. Salinas, good morning, sir.
Morning, Judge.
You're here on F-1757-21-4 in the matter of the marriage of Fernando Davila and Liza
correct,
Maria Morin. And we're set for final divorce, right, sir?
And we're ready to go forward, Judge.
Doesn't have an attorney because Lucy Thompson is attorney.
Oh, okay. Miss Morin, you do
Sí.
not have an attorney. You do not.
Señora Morin, ¿usted no tiene abogado?
No, todavía no. Estoy esperando respuesta de un abogado que me va a representar.
No, not yet. I'm still waiting for a response from an attorney that is going to represent me.
Okay.
Well, Judge, we're going to object to that. We want to go forward. I spoke to her yesterday. She doesn't even know if the lawyer is going to represent her because he's claiming he's got a conflict, or she's claiming she's got a conflict. I don't know if you want me to stop before I continue and give.
Oh, okay. And then your client, Fernando Davila, that's the one on the screen, right?
That's
Señora
correct.
Morin, el señor Salinas se opone porque él dice que usted no sabe si ese abogado la va a representar o no, que tal vez hay un conflicto o que usted tenga un conflicto con el abogado.
No, no, señorita, ese no es el caso. Su
No, that's not the
señoría,
case. Your Honor?
Su señoría, lo único que le pido yo es un tiempo
The only thing that I
para
ask is some time
juntar la cantidad de dinero para pagarle al abogado que
to
me va a
raise the
representar.
funds so that I can pay the attorney that is going to represent me.
Yo ya hablé con él, ya tuve una entrevista.
I already spoke with him. I already had an interview.
Ajá. Y él lo único que está esperando es que no esté en conflicto para atender mi caso, pero sí me va a representar.
The only thing that
Entonces-
he's waiting is just to to check or verify that there's no conflict, but he is going to represent me.
Okay, now, in this case, Mr. Salinas, is there children and property?
Judge, they are working under an agreed order where they're splitting the custody, where we're sharing possession of the children. I hate that word custody. I don't know why. They're sharing possession of the children.
Okay.
And I wanted the court to take judicial notice of the fact of how old this case is. It's very old, and this lady's always causing problems. Apparently, she's taking direction from somebody that's with her. She's at some law office or somewhere. I'd like to know if that's true, because we need to go forward, Judge. My client has offered.
Okay.
I'd like to find out where she's at, because it looks like she's in somebody's office.
Okay, first of all, when was this case filed? You said, it's a 17?
Yes, Judge, it's an
17?
extremely old case.
Okay.
And then the last time we were here, you told them, look, this is the final date.
Okay. Oh, 21. Okay. And then what agreement you said you're talking about that you're working under?
Well, the thing is that the order to withdraw was granted, and I gave Mr. Varela a copy of it yesterday on the 10th of March. The problem she had with Ms. Thompson even predate that. So the fact that she hasn't found a lawyer is just out of my mind. And Mr. Varela is telling me that she's going to drag this on as long as the court allows her to do it.
No.
But,
yeah.
Right. And I'm not saying I don't agree with that, Judge. I think the court gave us this date as a final date. So she's had more than 30 days to find a lawyer. And I don't doubt that she's probably at a lawyer's office now trying to get some kind of continuance. But this is unfair for my client because he's been shouldering all the debt between these two folks. That's number one. My client had offered her, and I told her this yesterday, and I was able to do it, even though she did not want to respond to my text messages or calls.
Okay.
Finally, I told her, listen, it's the court's policy. If you don't have a lawyer, I will get a call from somebody on the court staff asking me to reach out to you to see if you're in agreement with A, B, C, and D. What we offered her, what Mr. Varela told her, listen, even though there's a split possession order, he's willing to still pay the $2,300 in child support, even though he's going to have his daughters half of the time. She was making a big issue about a $200 difference. I told her $9,200 presumably is the max amount. You take 25% of that. It gives you exactly what, Judge? $2,300. My client also agreed that we could sell the house. And once the house is sold, minus the expenses, and she shakes her head, she may not like it, but that's just the way it is. Sell the house, pay the debt, and split the difference in whatever equity may be left. And they can agree. But we need to start the process already, right? There are some credit cards that I unfortunately told Mr. Varela, my client, that those credit cards are underneath his name. So even if you ordered her to pay half of them, he's got the dubious task and the problem of contractually continuing to pay those. Other than that, Judge, there's another house at Cimarron that was sold. We talked about it the last time. There's about $40,000, $50,000. That money, my client is ready to tell you under oath, was all expended on community debt. She hasn't done anything to pay any of these issues. So my client's extremely tired. He's exhausted. He'd like to just get divorced.
Okay.
If she doesn't like it, maybe she can hire somebody to file a motion for new trial or whatever it is, but she's had plenty of time to do this.
Okay, so you said on the credit cards, they're under his name?
They're under his name. And unfortunately, I told him that no matter what the court does, he's going to have to pay for those.
Yeah.
I mean,
okay.
And he said, you know what, if they're under my name, and Mr. Varela, he can hear me, he'll pay for them.
Okay.
We just need to be done with this and list the house and move forward, Judge.
Okay. Court will take judicial notice of the entire filing cost number F1757-21-4 in the matter of the marriage of Fernando Davila and Liza Maria Murin. All right, Mr. Davila, raise your hand, please. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Salinas, you may proceed.
Mr. Davila, could you please state your full name for the record?
Fernando Varela Davila.
And Mr. Varela, do you go by Varela or Davila?
Varela.
Okay, Mr. Varela, are you currently married to who? Can you tell the court?
Lisa Maria Vasquez Morin.
And is she on the screen right now?
Yes, sir.
And have you had multiple discussions with her regarding the division of the debt and issues pertaining to the children?
Yes, sir.
And in fact, yesterday, I even got a little frustrated with you because I'd spent the better part of the morning trying to get a hold of her, correct?
Yes, sir.
And we were supposed to meet, and that was delayed because I was actually trying to get a hold of her to have some communication with her to determine what we were going to do with what was left in this divorce, correct?
Yes,
Su
sir.
señoría,
All right.
no estoy
Now-
entendiendo nada de lo que está diciendo.
Your Honor, I'm not understanding anything that he's saying.
Okay, I guess when it comes to the division and things like that, Mr. Salinas, we'll interpret, okay?
Cuando estén hablando de la división de la propiedad es cuando le voy a interpretar.
And the children.
Ahorita nada más le está preguntando que son preguntas común.
Gracias.
Okay.
Su nombre, que si está casada con usted, cuándo se casaron, que si
Yeah.
usted está en la pantalla.
Yeah.
I can ask him the questions in Spanish, Judge, and if the court.
Oh, no,
reporter-
you do it in English
Okay,
and we'll just,
all right.
Or if you can just let me interpret, Rick, please. That way
Yes.
she's
she
understanding.
can hear, yeah.
And then just allow me time to say it in English for the record.
Okay, I'll take it in pieces.
Thank you.
Now, Mr. Varela, everything in your petition for divorce is true and correct.
Yes, sir.
Señor Varela, todo lo que está en su petición es cierto y correcto. Sí, señor.
And I'm talking about jurisdiction, venue, and the dates of birth, dates of separation, and all the information concerning your children, correct?
Yes,
Estoy hablando de los fechas de nacimiento de los niños, de que usted ha vivido aquí en el estado de Texas, en el condado de Hidalgo. Eso es lo que me estoy refiriendo.
Fecha de que se- de
Y
que-
la fecha que se casaron. Sí, es correcto.
And Mr. Varela, right now, what's left for the court to divide is a home, correct?
Basically, that's it. And we had discussed that in temporary orders that it would be sold.
Señor Varela, realmente lo único que queda ahorita para dividir es nada más una casa. Sí, es correcto, una casa, pero en órdenes temporales ya habíamos llegado a un acuerdo que esa casa se iba a vender.
Okay. And are there any other properties out there other than the house? And I'm talking about real property, land.
No, sir.
¿Hay alguna otra propiedad allá afuera que no hemos discutido? Estoy hablando de tierra. No, señor.
And Mr. Varela, there was a
Okay,
house
wait.
¿Puedo hablar?
Señora, no. Ahorita deje que termine el señor Salinas y usted puede preguntarle a la corte o decir lo que usted quiera ahorita que termine. Ahorita nada más escuche.
Ok.
And Mr. Varela, there was a house at Cimarron that we had discussed with your wife yesterday. That house was sold, correct?
That house was sold. Yes, sir.
Señor, y había una casa en el Cimarron que discutimos con su esposa y esa casa se vendió. ¿Es correcto? La
Yes,
respuesta sí, se vendió.
And in a general sense, without having, there was probably about $40,000 or $50,000 in surplus after the sale of the home, correct?
Yes, sir.
Y después de la venta de casa quedó de ganancia como unos de 40 a 50 mil dólares. La respuesta del señor es sí.
And you used that money during the pendency of this divorce matter to pay off some of the community debt that you and Mrs. Varela had together, correct?
Yes, sir. I've been using that money to sustain her, to pay her, support my children's support, psychological therapies, community debt. And it's been over $120,000 been me paying since the day of separation.
Okay, let me stop you there. Give him a chance to interpret.
Y ok, ¿y usted qué hizo con ese dinero, con esa ganancia? La respuesta del señor Varela, lo que he hecho con ese dinero es para sostener a mi esposa y a mis hijas. He pagado biles, también he pagado para las terapias que las niñas están yendo a terapia y todos los costos de este divorcio hasta ahorita es una cantidad como de $120,000.
Okay, and in your discussions with Dr. Guilantan, she's the therapist that's been looking after your two girls, correct?
Yes, sir.
Y la doctora o el doctor que está dando la terapia es el doctor Quilantán. La respuesta del señor, sí, señor.
And at this point, in an effort to resolve this in an amicable way, you're willing to continue with the 50-50 split of the access and possession of the children. Is that correct?
Yes, sir.
Y para poder llegar a un acuerdo, ¿usted está dispuesto a seguir con dividirse el tiempo de los niños, 50% usted y 50% la señora? ¿Es correcto? Y la respuesta del señor, sí.
And that's the way it's been happening since an agreed temporary order that was entered into months ago, correct?
Yes, sir.
Y esto es lo que ha estado ocurriendo desde que la corte entró esas órdenes temporales, ¿correcto? La respuesta del señor, sí.
Okay. And your two daughters, with your input, they're managing to get through this separation or this divorce, correct?
They are having a difficult time to get through this divorce. I've been talking to them, taking it to therapy, and they just simply, they need to get a closure on this. They don't know what's going on. They just simply need to move forward. All of us.
Let me stop you there. Give them a chance to interpret.
Y con la ayuda de usted y las terapias que sus hijas están yendo, esto le están ayudando a ellas para que puedan salir de que no entienden del divorcio. La respuesta del señor, sí, ellas están confusas, no entienden, están yendo a terapia. Lo que necesitamos es cerrar ya esto para poder seguir adelante y seguir a lo que sigue.
I've told you that after this today, that it's you, one parent, the mother, Mrs. Varela, the other parent, and the most important parent supervising everything you're doing is the judge in this courtroom. You understand that?
Yes, sir.
Yo le he dicho a usted, señor Varela, que después de que el divorcio esté finalizado, usted va a ser un padre, su esposa es una madre, pero el padre aquí más importante de sus hijas es el señor, el juez, Fred Garza. La respuesta del señor, sí.
And you understand that if in the future there's problems with Mrs. Varela or her parenting skills, you can always come back to court and ask the court to revisit the access and possession order. You understand that?
Yes, sir.
Y usted comprende que si en el futuro hay problemas con la señora Varela, entonces usted podrá venir a corte para que la corte vuelva a visitar, ya sea las visitaciones o lo que esté pasando con las niñas. La respuesta del señor, sí, señor.
So today you're willing to pay $2,300 a month in child support, which is a maximum amount under the guidelines. And you understand, Mr. Varela, you're also willing to provide health insurance for your daughters, correct?
Yes, sir.
Y ahorita usted está dispuesto a pagar de mantenimiento para las niñas $2,300, que es lo máximo bajo la ley, y también pagar la aseguranza médica para las niñas. La respuesta del señor, yes. Sí, yes, sí.
And you understand that the credit cards that are under your name, even though the judge could equitably divide that debt, you understand if she doesn't pay, that debt would be yours contractually because the credit cards are underneath your name. You understand that?
Yes, sir.
Y usted comprende que tocante las tarjetas de crédito, como están al nombre de usted, aunque la corte le ordene a ella que ella pague, y si ella no paga, últimamente usted es responsable por esas cuentas porque están bajo de su nombre. La respuesta del señor, sí.
And you also understand that you can ask Mrs. Varela, even though highly unlikely, you can ask her for an accounting, you can ask her for an inventory, but you're waiving that because you feel that you're sufficiently familiar with the marital estate, correct?
Yes, sir.
Y usted también comprende que usted tiene el derecho de preguntarle a la señora Varela que haga una cuenta de toda la propiedad que hay en la casa, los bienes del matrimonio, pero usted ahorita está pidiendo rechazar eso porque usted sabe y conoce la propiedad que hay en el matrimonio. La respuesta del señor, sí.
Now, this is the last question I want to ask you. Does Mrs. Varela have an education? I think it's in Mexico, correct?
Yes, she does.
Esta es la última pregunta que le voy a preguntar. La señora Varela tiene educación, me parece que es en México. La respuesta del señor, sí tiene.
Can you give us a short description of what she's educated, what she's able to do, just for the record?
¿Me puede decir brevemente qué es la educación que ella tiene y qué es lo que ella puede hacer? Brevemente.
Yes,
Respuesta del señor, sí.
She has a bachelor in marketing from a university in Reynosa, and she's worked before in insurance, selling insurance, and she has worked on that.
Ella ha trabajado con aseguranzas
Tiene una beca en
y
marketing.
Bachillerato. Tiene un bachillerato
sí,
en
un bachillerato en Marqueta,
Mercadotecnia.
en mercado técnico Marqueta.
And you're asking this court for a divorce, correct?
Yes, sir.
¿Y usted le está pidiendo a esta corte un divorcio? La respuesta, sí, señor.
Mr.
Your
Salinas,
Honor.
do we need the names of the children?
Mr. Varela, can you give us the names of the children, please?
Señor Varela, los nombres de las niñas, por favor.
Lisa María Varela Vázquez, Fernanda Varela Vázquez.
Okay. Very good.
I don't know if Mrs. Varela has any questions for Mr. Varela, but I'm finished.
Okay, Miss Varela.
Señora Varela.
I'm sorry, Miss Morin. Lisa Maria Morin. Any questions that you want to ask right now?
Preguntas que usted quiera preguntarle al señor Varela.
No, no tengo nada que preguntarle a él.
No, I don't have anything to ask him.
Okay, while ago you had your hand up. What you want to say?
Usted tenía su mano levantada. ¿Qué es lo que quiere decir? ¿Puede bajar su mano?
¿Puedo bajarla? Sí.
Sí.
Sí, solamente sí no estaba entendiendo lo que estaban comentando, pero ya cuando usted tradujo, sí lo estoy entendiendo. No sé ahorita qué me permitan decir o qué pueda decir para hablar
Yes,
con
the only question I
señoría.
had before is that when he was being asked questions, I didn't understand, but once you started translating, I understood the questions. I don't
Okay.
know what it is that I can ask right now.
Well, no, if you understood what's going on here, anything you want to add or something, or
No, si usted
anything
ya,
that was left out?
si usted comprende lo que está sucediendo ahorita, ¿hay alguna cosa que hayan dejado fuera? ¿Algo que quiera agregar?
No, lo único que quiero decir ahorita, su señoría, es que le pido por favor me dé el tiempo, un plazo, para yo ya tener a mi abogado, porque siento que se ha abusado de mi ignorancia ante muchas cosas. Yo siempre confié en el señor Fernando Varela, desde el primer momento en que él dijo que quería el divorcio, y hasta el día de hoy seguía confiando, ¿verdad? Pero me han hecho firmar cosas que yo por mi ignorancia no sabía. Entonces, le pido por favor un plazo nada más para que mi abogado me diga mis derechos y los derechos de mis hijas.
The only thing,
Todo lo
Judge,
que
that
pido.
ahorita sí, ¿verdad? That I am requesting is that you please allow me some time so that I can hire an attorney. Excuse my ignorance. I've always trusted Mr. Varela. I've signed documents that I don't know what I have signed. And I'm just asking for some time so that the attorney can explain to me what my rights are.
Okay, now what the court just heard earlier, ma'am, it appears that there's a fair and equitable division of the estate here. And as far as the 50-50 possession or custody of the children, that'll be part of the decree. So what the court wants to do is just proceed with the final divorce today, and then you will have you still have time to find an attorney if they want to file a motion for your trial.
Señora Varela, lo que el juez acaba de decir ahorita es que lo que él ha escuchado ahorita es una división de la propiedad de ustedes justa, ¿ok? 50% y 50% de los niños, usted con las niñas y el señor con las niñas, él va a pagar mantenimiento, aseguranza médica. Lo que la corte va a hacer hoy es, él va a conceder el divorcio, los va a divorciar hoy. Usted tiene 30 días para que usted lleve este documento con un abogado. Es importante de que el decreto de divorcio que el juez va a firmar, y tiene 30 días después de hoy, y ya entonces ya usted decide si usted quiere archivar una moción para que el juez vuelva a abrir el caso. Pero hoy él va a concederle al señor Varela el divorcio.
Disculpe, señoría, que es 50 y 50, porque no estoy de acuerdo y necesito de verdad que me dé un tiempo. Yo no estoy de acuerdo en que se haga hoy el divorcio. Necesito.
What is 50-50? I need an explanation. I'm not in agreement, and I really need time.
Okay. Mr. Salinas, on the possession of the children, that was 50-50, right, sir?
Your Honor, just quickly for the record,
And he's gonna pay the 2,300 monthly, right?
that's correct, Judge. And
Right.
this is an agreement, just so the record's clear. This is an agreement that they've had for many, many months. And it was an agreement that was reached either with Mrs. Thompson or another lawyer, I don't remember, but it's been while she's been represented.
Mhm.
What she's complaining about is her lawyer. That's what in my discussions with her yesterday, that's what it was. She's not complaining that Mr. Varela lied to her. She's got an issue with her lawyer, and I can't resolve that. I don't know what it is. I mean, I think that she's claiming that what she was told, but they've never filed anything to set that aside. And the children are now acclimated to this split possession order. And in fact, Judge, just for her to know, Mr. Varela has been very kind, because at one point he was considering asking for custody because there's some issues with her in the way she parents the children. But today, Mr. Varela's in understanding that he can always come back in the spirit of compromise and settlement. He's willing to let that go and continue to do this. And we're hopeful that Mrs. Varela will do well on the visits.
Señora Varela, el 50% y 50% es que las niñas están con usted 50% del tiempo y 50% del tiempo con el señor Varela, y él le va a dar mantenimiento para las niñas en la cantidad de 2,300 por mes, y también va a tener aseguranza médica para las niñas. Esto es algo que han estado haciendo desde que la corte entró con las órdenes temporales. Esto no es nada nuevo. Ahora nada más la corte lo va a hacer final.
No estoy de acuerdo, su señoría. Yo tenía una abogada que era la licenciada Lucy Thompson.
No, I'm not in agreement, Your Honor. I used to have an attorney. Her name was Lucy Thompson.
La cual dejó de representarme porque el señor Varela dejó de pagarle, y él amenazó en una mediación de que él iba a dejar de pagar.
The reason that
no
she withdrew is because Mr. Varela stopped paying her fees, and he threatened her at a mediation. And that's the reason why she withdrew.
Así es que por favor yo le suplico y le pido que yo quise llegar sola aquí a la corte, creyendo en la buena fe del señor Fernando Varela.
Wanted to be here by
Pero
myself,
después hablé
trusting in Mr.
con
Varela's.
una persona que me orientó y me dijo: tú no puedes llegar sola a la corte, tú necesitas a alguien que te represente. Yo apenas, señoría, tengo 2 meses de estar trabajando en el consulado de México aquí en McAllen.
Señora, un momentito.
Ma'am, did you have an agreement between him and, between you and Mr. Davila before in this court?
Usted tuvo un acuerdo en las órdenes temporales con el señor Varela antes.
Sí, y la licenciada Lucy me dijo: es órdenes temporales, eso no significa que se vaya a hacer, son órdenes temporales solamente.
It was just temporary orders.
Right. And basically what was done here today was
por el bien de las niñas, era por el bien de las niñas.
right.
Entonces, yo no estoy de acuerdo en el 50 y 50.
And I'm not in agreement.
Okay, you still have 30 days to show the document to an attorney, and he or she may file for a motion for new trial. Okay, ma'am?
La corte va a conceder el divorcio hoy, y usted tiene 30 días para ir a buscar un abogado, y si quiere archivar una moción para un juicio nuevo.
Court will hereby take judicial notice.
No estoy de acuerdo en que se firme el divorcio hoy.
Court will take judicial notice of the entire filing F-1757-21-4 in the matter of the marriage of Fernanda Davila and Lisa Maria Morin. Court will hereby dissolve the marriage of petition respondent. Court will go ahead and approve the agreement of the parties that they had before and make it into a final hearing here. And court will await a decree for signature. Okay?
Thank you, Judge. That's all we have.
You all may be excused. Thank you very much.
Thank you, Judge.
Next, please.
Okay, Rick Montalvo.
And John Schultz. And John Schultz. Or unless somebody's for
I
you.
don't know what the attorneys are working there with.
Rick, can you hear me?
I'll let the judge know, sir. Yes, sir, Judge.
Rick Montalvo is on one side and John Schultz is on the other side. Is anybody standing in for John Schultz?
I don't have any information
To that effect.
Standing in for Mr.
Unless
Schultz.
Mr.
Yes, sir.
unless Mr.
All right,
Montalvo-
let's hear from Mr. Montalvo now. Yes, sir,
Good
Mr.
morning,
Montalvo. Good morning, sir.
Your Honor, I did speak to Mr. Oscar Lanise on behalf of the defendant. I'm not sure the insurance company's name, but we did speak on the phone just a few minutes ago.
Okay, and who was that attorney?
Oscar Lanise, sir?
Oscar Alanis.
Right here.
There it is, right there. Okay.
Thank you for your patience, Mr. Montalvo. We just had a contested divorce.
I imagine there's no such thing as a brief announcement on family.
There's no brief announcement and there's no uncontested divorce. Okay. Those
Especially
are-
with certain attorneys.
Mr. Oscar Lanise, there he is. Good morning, sir. All right.
Good morning, Judge.
All right. Good morning. Thank you for your patience, sir. I think you're here on CL 1861-59D Juan Hernandez versus Mario Martinez Cantu.
That's correct, Judge.
And we're here on a motion to dismiss. Is it defendant's motion to dismiss?
It's defendant's motion to dismiss, Judge. I did speak to Mr. Montalvo just a little bit earlier, Judge. I know he filed a motion also to have an appointed representative for the deceased defendant so this case can move forward. So on my motion, I'm not going to proceed forward with it, Judge, because Mr. Montalvo is moving the case. His motion is not set today, Judge. I understand that, but just on my motion to dismiss, at this point, Judge, I'm not going to pursue that because Mr. Montalvo filed his motion.
Okay. Then there'll be no action here today. And I'll allow the both attorneys to continue discussing the matter and see what else you want to file in the future, or, you know.
Yes, Your Honor. I did file it, Your Honor, and as Mr. Alanis has mentioned, it's not set for a day, but it's just a motion so that the clerk can issue a service again on the estate of the
Or
deceased.
representative for somebody.
Yes, Your Honor.
Okay.
That's it.
No action today then, okay? We'll
Yes,
leave it
sir.
like that.
Thank you, Your Honor.
Thank you very
Thank you,
much.
Judge.
Both may be excused. Have a great day.
Thank you, Your Honor.
You too,
Yes,
Judge.
bye-bye. Okay,
Number 5.
number 5.
I think somebody's here for Edward
All
or
right,
for Mr. Rafael de la Garza.
all right, let me see here.
I need to know who's on the other side.
All right. All right, can you hear me, ma'am? Ashley,
Yes,
is
ma'am.
it Ashley Rincon?
Yes,
And
Sorry,
you're here
Judge.
for Mr. De La Garza?
yes, I am.
Okay, let me
Who's on
put
the
here,
other side?
Ashley Rincon. And who's on the other side? Edward Castillo? Or is it
I-
somebody else?
I believe so.
On the record, it's Edward Castillo, but sometimes they'll have somebody stand in.
Who found the motion?
Whose motion
Ray,
is?
can you check, or Rachel? What other names are on the motion?
Yes, ma'am. I'm sorry, can I have the case number?
Yes, CL 21-1742D.
Unless she's been talking to somebody else and she can give us a name.
Yes, ma'am.
I'm looking for that information right
Oh,
now.
okay, okay.
The MSJ.
We know it's a motion for summary judgment.
Okay.
I have Mr. Moya,
Moya is another name?
Ezekiel Moya. and
Ezequiel
Cassandra
Moya?
Diaz.
From the office of Edward Castillo.
Yes.
Ezequiel Moya. Okay, let me look for a Moya.
Ezekiel Moya, and I also see a Cassandra Diaz.
Cassandra Diaz.
Yes.
Yeah,
Okay, I
that's
see a
right.
Cassandra Diaz.
right.
Okay, I think we got him already. Let me see. Thank you, Rach.
You're welcome.
All right, let's see who's gonna be there because I saw two names that were kind of,
Yeah,
they were
Cassandra
kind
Diaz.
Miss Cassandra Diaz.
She's to unmute.
Yes.
All right, good morning, Ms. Diaz. You're here on CL 21-1742D, right, ma'am?
Yes, sir.
And this is the case of Maria Yolanda Pulido versus Ross Stores, Inc., DBA, Ross Dress for Less. And we have a motion for summary judgment, right, ma'am?
Yes, we do. Yes, Your Honor.
Okay, and whose motion is it? Is it defendant's motion?
Yes, it's defendants.
Okay, and did the plaintiffs file a response?
Yes,
Yes,
Your
they
Honor.
Okay. All right. Well, then, Miss Diaz, I guess you may proceed.
Yes, Your Honor. So this case is a premise liability case.
Yes.
Plaintiff alleges in their current live pleading that on August 29, 2019, that she walked out of the fitting room area when she slipped and fell as a result of an item on the floor. She claims that there were misplaced items on the floor, that Ross should have known of the unkept floor. The floor was untidy. The items on the floor posed an unreasonable risk of harm, and that they should have had a clean floor surface. The court should grant defendant's motion because plaintiff cannot prove the elements of her case alleged in her live pleading. She testified in her deposition that she didn't fall on an item, that the area was clean. She was asked 4 times. She continued to say that she did not fall due to an item, that there was no item, the floor was clean, that she didn't see anything. The elements of premise liability, as you know, there has to be a condition that posed an unreasonable risk of harm. In this case, as she testified, there was no item. Therefore, there was no dangerous condition that posed an unreasonable risk of harm. The next element, defendants knew or reasonably should have known of danger. Like we've already said, there was no danger for them to even know about because there was no item on the floor. Finally, defendant failed to exercise ordinary care. She also testified that the walkway was clean. There are no facts that the plaintiff can show the court to prove that an item was on the floor, as alleged in her live petition. The plaintiff is not able to produce any evidence of an item on the floor to show that a dangerous condition existed. Therefore, the court should grant defendant's motion for summary judgment. Additionally, plaintiff now, for the first time in her response, is claiming that there is a slippery, shiny, waxy floor. This is the first time this has come up. This is not her current live petition. Like I said, her current live petition alleges that she fell due to an item. And now she's alleging that the dangerous condition is a waxy floor. That's nowhere found. There is case law under Harold v. Shamrock. The Court of Appeals held that pleadings do not constitute summary judgment proof and are not considered in determining whether fact issues are expressly presented in summary judgment motions. In that case, the appellant was not able to raise new issues in their response to appellee's motion for summary judgment. Likewise, plaintiff should not be allowed to raise new issues such as the waxy floor as a reason for the court not to grant defendant's summary judgment motion. Therefore, the plaintiff has failed to raise any issue of fact. Finally, the plaintiff claims that there has not been adequate time for discovery. Plaintiff filed their petition on May 4th, 2021, 11 months ago. That's more than enough time. The defendants deposed plaintiff on August 9th, 2021, 8 months ago. The plaintiff has not requested any depositions of defendants, corporate representatives, or employees. They haven't even requested dates. Defendant responded to plaintiff's discovery request on July 7th, 2021, 9 months ago. Plaintiff has not filed any motions to compel. Finally, the defendants filed their motion for summary judgment on March 9th, 2022, a month ago. That gave the plaintiff 7 months to amend their petition from the deposition until we filed our motion for summary judgment. Therefore, there's no evidence showing that there was a dangerous condition because there was no item on the floor that posed an unreasonable risk of harm that defendants knew or should have known. Instead, defendant Ross exercised ordinary care because, as plaintiff stated in her deposition, the walkway was clean. Therefore, we ask the court to grant our motion for summary judgment with prejudice.
All right, thank you, ma'am. And Ms. Lincoln?
Yes, Your Honor. So upon review of the defendant's motion, they titled their motion
as a traditional motion for summary judgment, but they make no evidence arguments within their motion. So we ask that the court see it as such. And furthermore, we ask that the court review the evidence presented by the motion and response in the light most favorable to the party against whom the summary judgment was rendered. So regarding the motion, they do not make any reference to plaintiff's motion for negligence, their claim for negligence. They only make a motion against plaintiff's cause for premises liability. However, regarding the negligence claim, plaintiff does present more than a scintilla of evidence regarding defendant Ross's negligence, being that the plaintiff did fall on the store's slippery surface. Now, in her deposition, she did not allege that the floors were she's alleging that the floors were the actual cause, the dangerous condition itself, not that she slipped on an item. So when counsel asked about the items, she was making reference like it wasn't an item that caused her injury. She testified that it was the slippery floor. When asked to elaborate as to what she meant by that, she said it was very shiny. She also explained that when she was attempting to get herself up, that her hands kept slipping on the floor. So we're arguing that the dangerous condition is the floor itself. And there was an investigation done on the insurance's part as to the accident itself. And the investigator noticed that the floors were waxed 5 days previously to the accident. There was no mention in his report of any employees sweeping the area or vacuuming the area right before the accident. So there is a link between the cause of the injury and the injury itself that the plaintiff is claiming. Regarding the premises liability clauses, the fact issues exist as related to the plaintiff's premise liability claim, in the fact that the defendant had active or constructive notice of some condition on the premises, being the dangerous condition of the floors. The condition posed an unreasonable risk of harm in which that the plaintiff fell. The defendant did not exercise reasonable care to reduce or eliminate the risk. They did not add any signs or warnings. There are a lot of employees in the area, given that where the plaintiff fell was near the dressing rooms. So in that area, there are many employees monitoring, and even their handbook states that employees are charged with monitoring those areas to make sure that there is an easy path for customers to reach to the dressing rooms. And lastly, the defendant's failure to use such proximate. Sorry, a little bit tongue-tied. The defendant's failure to use care proximately caused the plaintiff's personal injuries. And overall, there was no intervening injury that caused pain to the plaintiff. After she fell, she received medication from I believe an employee. She waited for the medication to take effect before leaving the store. And then after that, she went to go see a physician. Now she reports pain in her back and her legs. And that is an overall view. But to get into specifics regarding the defendant's notice of, or that they knew of the dangerous condition that caused the plaintiff to fall, is that they had constructive notice of the condition. So they knew that the floors had been previously waxed, and so that they should have known to make certain measures to prevent anyone from falling down. No signs were added, and there was a lot of employees in the area where she fell down, highly trafficked by both customers and employees, and they should know to watch out for the floors, given that they've been re-waxed or scrubbed again. In Walmart versus Reese, the law does not require that a plaintiff remember how she fell or how long the dangerous condition existed before imputing knowledge onto the defendant. The law only requires that the existence of said condition exist, regardless of plaintiff's memory of it. Defendant Ross knew of the dangerous condition which caused the plaintiff to fall by means of construction notice and the fact that they knew the floors were scrubbed and waxed previously to the accident. In regards to whether the condition posed an unreasonable risk of harm to the plaintiff and other invitees, the defendant continuously claims that there were no objects on the floor that caused the injury, and that is not what the plaintiff is contending. We're contending that the floors itself were the dangerous condition, and they were excessively slippery, which caused her to fall down. And as such, we believe that a motion for no evidence for summary judgment should be denied in its entirety. In regards to whether a defendant exercised reasonable care to reduce or eliminate the risk, the plaintiff testified that yes, the walkway was clear and no items on the floor, but it was the condition of the floor itself that was slippery that caused her to fall down. And furthermore, we're not only just relying on the testimony, we're also relying on the investigation by the defendant's insurance, and the handbook, defendant's handbook for their employees, as proof that they should have acted with ordinary care to prevent injuries to their invitees, of which plaintiff was an invitee and was not a trespasser at any time. So the defendant breached its duty of care to exercise ordinary care to protect the plaintiff from danger by failing to adequately warn the plaintiff. There were no employees warning the plaintiff about the slippery floors, nor any signs to watch out for that area. And lastly, regarding the failure to use care proximately caused the plaintiff's injuries, again, right after the plaintiff fell, she was attended by, I believe, an employee, was given medication. She waited for that medication to take effect before leaving the store. And then after that, she went to go seek a physician. So there was nothing intervening from the moment that she fell down at the defendant's premises and her injuries that she is now enduring. And lastly, regarding the timing of the summary judgment, sufficient time has not passed in discovery. I believe, yes, that the plaintiff filed suit on May 3rd of 2021, which is 10 months ago, but the discovery period has not ended. We have not had the opportunity to depose the defendant's corporate representative, nor file a motion to compel the defendant's responses. We have filed a docket control order on this case, and we are currently waiting for a discovery deadline, of which a deadline has not even been issued in this case. And it is in our next course of action to file our notice for defendant's corporate representative and file our motion to compel. And because of reasons that I have stated, we are asking that the court deny defendant's no evidence motion for summary judgment.
All right, thank you, ma'am. Ms. Diaz?
Yes, Your Honor. This is actually a liability case. It's not a negligence case. The plaintiffs are not claiming that Ross negligently acted or did an action that would cause negligence claim. It's a premise liability claim. Furthermore, our motion is for a traditional and no evidence motion for summary judgment. Further, this wax situation should not even be mentioned because that's not in the current life petition. That's not what plaintiff is alleging. Plaintiff's claims are that there was an item on the floor and that's why she fell. They had time to amend it. They did not amend it. Therefore, there's no reason why wax at all should even be mentioned. If they wanted to allege that the floor was waxy, then that's what should have been in the petition, and it's not. Therefore, we ask that you grant our motion for summary judgment with prejudice.
All right, then what court will do is go ahead and take judicial notice of the entire file. Court will go ahead and take this matter under advisement. And I think Ms. Pulido's depo's already been, are there, she's the only one who's been, yes.
If I may respond.
Sure.
So in regards to plaintiffs needing to amend, Your Honor, the cure is to amend our petition, not for a motion for summary judgment. However, we are, in our live pleading, we mentioned that the floor was the dangerous condition. So we have always presented as such that the floor was the dangerous condition that led to the plaintiff's injury. So like I said, the care in this case would be to amend, not for a granting of a motion for summary judgment in this case, Your Honor.
Okay. All right, court will go ahead and take this matter under advisement. We'll go ahead and review the matters again, and we'll hopefully come up with a ruling in a week or so. All right, thank you very much. You may be excused. Have a great day.
Thank you. Thank you, Your Honor.
Number
Bye-bye.
7.
Number 7,
Mr. Ismael, please.
Mr. Ismael. Oh, the attorney, is it gonna be, okay.
Good morning, Judge. Let me get him. He's in another Zoom hearing.
Oh, okay.
There should be a quicker announcement.
Who else is just
Yeah,
here?
Number 10. Yes, it's
It's just
a
him.
motion to transfer.
Okay. All right,
And then number 10,
okay.
Hernandez versus Hernandez.
Number 10, you said?
Good morning, Your Honor.
Yes, sir, Mr. Peace?
Correct,
You're
Your
here,
Honor.
you're here on F0961-17-4 in the matter, in the interest of Sadie, Madison Guerrero, and Amaziah, Michael Guerrero? Yes, sir.
Your Honor, we're here on a motion to transfer
Uh-huh. Transfer the case to,
El Paso County, Your Honor.
Wait.
Both
okay,
petitioner and who's the primary caretaker of the children, and the children have lived in El Paso since March of 2020, Your Honor. Petitioner's requesting that the case be transferred to El Paso County at the court's discretion. Venue would be proper here in El Paso County.
okay. Is Mr. Guerrero anywhere? Is he gonna be appearing or?
I don't see him, Your Honor, and I apologize. I'm jumping from court to court, so.
Okay, I don't see him in the waiting room either. And have you talked to him or anything? You know what?
Not to, Your Honor, so when, back on February 10th of 2022, I guess, his prior counsel was notified, and Ms. Dora Alicia Garza.
Okay,
I
Dora
thought
Garza.
she may have been present, but I don't see.
Okay, and I don't see her either in here. Okay, so you're saying that basically the petitioner was a resident of El Paso County?
Yes, Your Honor.
As provided by the statute?
Correct, Your Honor. And
Okay.
both the children are also residing in El Paso County.
All right. All right, the motion to transfer is hereby granted. Did you submit an order?
I did, Your Honor.
All right, we'll sign it later then.
Thank you, Your Honor.
That'll do it. Thank you very much. Have a great day, sir.
You too.
Bye-bye.
Number 10, Hernandez versus Hernandez, Pablo Garza and the state.
All right, that'll be P0095-20-4, Denise Hernandez and Jose Gabriel Hernandez. And it's a protective order?
Yes.
All right. I see Mr. Pablo Garza, and yes, Miss Belinda Saldua.
Yes, good morning, Judge.
Yes, ma'am.
I just filed a notice of appearance for the state, Your Honor. We just recently changed attorneys on this case, but reviewing the case, it looks like there is a felony pending, Judge.
That's correct.
And it looks like the parties were waiting to see what would transpire in that felony, Judge. I don't know, Mr. Garza still wishes to go ahead and extend the temporary expiry date order until the criminal trial.
That's fine with us, Your Honor.
Okay, so we'll extend it.
Yes, Judge. I see there was a pre-trial yesterday. I don't know if a trial date was set.
Okay.
I don't know,
So
Mr.
how
Garza
far-
knows.
We got set to, I believe, next week. The judge wanted to go over some things with us in that matter. And I do believe that's going to be set for a trial in the future, but we have, I think it's a status that's set for next week, Your Honor, in the
Okay.
felony, but it will be set for trial in the near future. We don't have a trial date yet.
Okay. So this extension here, how further do you want it?
Maybe 3 months.
I'm fine with that.
Let's do September,
To
and if the
September.
felony is disposed of way before, just to let the court know, and we can bump it up.
Right. Let's do it to September, and then if it is disposed earlier, just let the court know.
Okay.
Can we get a date in September, or do you want us just to
We need
file the
Put
order?
it in the order.
Yeah, we need the order, and we'll figure out a date, but just leave it blank, I guess, and we'll fill it in. It'll be September.
All right, thank you, Judge.
Thank you.
And once
Judge.
again, once you hear something, if you hear something earlier than that, please let us know.
Will do.
All right. Thank you very much. You're excused.
Thank you,
Have a good
Judge.
day.
Have a good day.
You too. Bye.
Number 8, Mr. Fonseca and Mr. Daniel Ramirez.
All right. Number 8. That'll be Mr. Fonseca. There he is. And Mr. Ramirez.
Good morning, Judge.
Good morning. F11 61-19-4. Miguel Guadalupe Cantu versus Luna Aide Ochoa. Are the
yes,
parties
sir.
in?
Yes, sir.
Okay, the parties are there, I guess.
They should be.
Okay. What do we need? What do we got to do here, folks?
Judge Daniel Ramirez representing Luna Ochoa.
Okay.
Aaron Fonseca representing Mr. Manuel Cantu, Your Honor. We actually went to formal mediation on April 7th, which was last Friday. We did reach an agreement, so we'd like to read that into the record so that we can go ahead and get a final order out of this.
All right. So you mediated and you were successful in mediation.
Correct, Judge.
Great. Good to hear that. Who's going to be testifying here?
Mr. Cantu needs to put video and unmute.
Yeah, Mr. Cantu needs to. Oh, there he is. Okay. All right.
Hi, Your Honor.
It's Mr. Fonseca. You want to call your client?
Yes, if Mr. Cantu, if I can call Mr. Cantu to testify.
All right, Mr. Cantu. Good morning, sir.
Good morning, sir.
Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you very much. You may put your hand out. And Mr. Fonseca, you may proceed, sir.
Sir, can you please state your full name for the record?
My full name is Manuel Guadalupe Cantu.
And you are the same Mr. Miguel Guadalupe Cantu that filed this modification?
Yes, I am.
Yes, and you are the father to, what is your child's full name?
Melody Rose Cantu.
Okay. And you've reached an agreement regarding the parenting plan, is that right?
Yes, we have.
Okay, I'm gonna go ahead and read out that what you've agreed to, and you tell me whether or not those statements are correct, okay?
Okay.
So it's gonna be 3 phases, correct?
Mm-hmm.
And you're gonna have 10 supervised visits occurring at Peter Piper Pizza in Weslaco, is that correct?
Yes.
Okay, and whenever you can mutually agree with mom, you can meet wherever you'd like, is that right?
Yes.
As long as you all agree. Okay, and then the visits shall occur on Saturdays beginning at 11 a.m. and ending at 3 p.m. on Sunday. Is that right? I'm sorry, let me rephrase. Saturday, 11 a.m. to 3 p.m., Sunday, 1 p.m. to 5 p.m. Is that right?
Yes.
And these visits are occurring on the 2nd and 4th weekends rather than the 1st, 3rd, and 5th. Is that right?
Yes.
And the first visitation is going to commence the weekend of April 23rd, 2022, correct?
Yes.
For this summer, you're not going to get any summer visitation regarding the standard length of under the family code, meaning you're not going to get the 30 days for summer. Do you understand that?
Yes.
Okay. And on phase 2, upon completion of phase 1, you're going to have 5 unsupervised day visits, Saturday and Sunday, Saturdays being 11 a.m. to 3 p.m., Sundays 1 p.m. to 5 p.m., correct?
Yes.
And these are on the 2nd and 4th weekends rather than the 1st, 3rd, and 5th, understood?
Yes.
On phase 3, after the completion of phase 2, you're going to have 5 overnight visits beginning Saturday at 4 p.m. and ending Sunday at 6 p.m. on the 2nd and 4th weekends. Is that correct?
Yes.
After you complete phase 3, you're going to have standard visitation for the Texas Family Code without the under 50 miles election. What that means is on 2nd and 4th weekends, you'll get your child Friday at 6 o'clock and end Sunday at 6 o'clock. Is that correct?
Yes.
Once the child turns 8, you will be electing the under 50-mile provision under the new standard visits. This will apply Thursday through Monday during the regular school term. Under this provision, you'll go ahead and revert to the Texas Family Code, which is the 1st, 3rd, and 5th weekends. Do you understand that?
Yes.
And is that correct?
It is correct.
Okay. Now, you've also agreed that once overnight visits commence, the child is going to have her own separate bed, and that no male adult other than you yourself, who is the biological father, shall be in the same bedroom as the child during bedtime. Is that correct?
Yes.
And you're going to continue to communicate via Talking Parents, the app that you're using. Is that right?
Yes.
And you're going to agree to communicate, this is for both of you, that both of you will communicate regarding to any changes in school or medical appointments, correct?
Yes.
Okay. Anything that is not specifically modified is going to remain as the previous order, including but not limited to child support and medical support. Is that correct?
Yes.
Okay. And then we're going to have some injunctive language specifically designated in the counterparty's counter petition, with as well as no disparaging remarks directly to and in front of the child. Is that correct?
Yes.
Okay. The parties agree that they will be the only ones present during the supervised visits. Is that correct?
Yes.
You agree that you will sign off on any necessary documentation for the application of a passport. Is that right?
Yes.
And mom shall be allowed to maintain that passport, and dad shall give reasonable notice of his intent to use passport. Do you understand that?
Yes.
And that's your agreement?
I agree.
Okay. The last portion is the parties agree to the right of first refusal provision. That is, in the event that either party shall be absent from the child overnight, they shall contact the other parent prior to such absence to give the party notice and the ability to pick up the child. Is that correct?
That is correct.
Okay. Is that a full and complete understanding of your agreement?
Yes.
Okay. Is there anything in that agreement that was either misstated or is something that you are unable to perform?
No. I understood everything.
Pass the witness, Your Honor.
Mr.
I don't
Ramirez?
have any questions of Mr. Cantu, Judge. I would just like to ask Ms. Ochoa some questions.
All right, Miss Luna Ochoa. Good morning, ma'am. You need to unmute.
Good morning, sir.
Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may put your hand down and you may proceed, Mr. Ramirez.
Thank you. Ms. Ochoa, state your name, please.
Full name is Luna de Ochoa.
You've listened to the testimony of Mr. Cantu regarding the settlement terms that were arrived at the mediation conference.
Yes, sir.
And you're in agreement with those terms?
Yes, sir.
Is there anything else you would like to add?
No, sir.
And Judge, it's important, and I'm just going to say this very briefly. It's important to note, Judge, that there was a child support order in this court, which was rendered on September 23rd, 2019. And this mediation agreement just modified certain terms. And part of this agreement is also that any other language in the child support order that was not modified at the mediation agreement will continue to be in full force and effect. Is that your understanding?
Yes, that's correct. So the medical and child support language will be copied into this new order as it was in the prior order.
Yes. And there's also some restrictions that
Yes.
apply to initial periods of
Okay.
possession and also to the standard possession. Are you in agreement, Mr. Fonseca, that those will remain?
Yes, anything that was not specifically modified will be transferred to this new order.
Thank you.
All right.
That's all, Your Honor.
All right. Any questions, Mr. Fonseca?
I think we're good to go, Judge.
Ms. Ochoa?
Oh, no, Your Honor.
No,
I
okay.
think that covers everything.
All right. The court will take judicial notice of the entire file in the case of Manuel Guadalupe Cantu versus Luna Aide Ochoa in cause number F1161-19-4. Court will hereby approve the agreement of the parties and will go ahead and await an order for signature. All right. Thank you all very much. You all have a big excuse. Have a great day.
You too, Judge.
Thank you.
Bye-bye.
Mr. Ricardo Rodriguez, number 4, and his client Rafael Soto.
Mr. Rodriguez, there he is, number 4, right?
Yes, sir.
And Rafael Soto.
Mr. Soto
I
needs to
think I
unmute.
saw him there. There he is. Okay, he needs to unmute. And then we're okay. And then Mr. Gwynn. There's Mr. Mike Gwynn right there.
Yes, Judge.
And I think we're here to hear that victim testimony.
Yes, Judge. I wasn't sure that the victim can show this morning, Judge, because I mean, the victim told me that she had an emergency in Mexico, so she might not be able to appear this morning, but
What's the name?
if you could check.
And what's the name, Mike?
The name of the victim is Juliana Regalado.
Juliana.
Juliana.
Regalado?
Yes, Judge.
A ver. Court will note that Juliana Regalado is not in the waiting room. Not available. Yes, sir, Mr. Gwynn.
Yes, Judge. If I could ask for a continuance, so I secure the witness for next time, Judge.
I'm sorry, I didn't hear.
Secure the witness for next time. He needs the testimony of the witness.
Oh, okay. So you're still asking for the witness's testimony, right? You still need that?
Yes, Judge.
Okay. But in the meantime, did you say that Mr. Soto already completed his anger management? What was it?
That is correct, Judge. He did complete his anger management course, and now the victim already filed an A&P with our office. Now we just hear testimony for the record.
Okay, so we're lacking the victim testimony. All right. What do you want to do? Give it a one more shot?
Yes, Judge.
I need to check the calendar, so
okay,
we'll get back with you.
Okay, we'll get back with you on that one, Mr. Gwynn and Mr. Rodriguez on another setting for the victim. But for the record, she's not available today. But we're kind of glad that Mr. Soto already took care of his situation.
Is there a number
anger management?
where we can call the witness?
What do we call?
Does Mr. Mike have a
Yeah.
number?
You have a phone number or something, Mr. Gwynn?
Yes,
For
Judge.
the victim?
Let me get it for you, Judge.
Okay. So just in case we get her and we can put her on speaker.
Okay, it's 956-619-4646, Judge.
4646-619-4646. You want to give it a try? We're gonna give it a try right now.
What's your name?
Juliana Regalado. But you did say that she had an emergency and she had to be in Mexico?
Yes, Judge. That's what she told me.
Okay, so far there's been no response.
Please leave your message for.
Okay, no response. So then, well, I guess we'll get back later with the parties with a new date. But Mr. Rodriguez, thank you so much for appearing. And Mr. Soto, thank you so much. We'll give it another try next time, okay? We'll let you know the next date.
Thank you, Your Honor. May we be excused?
Yes, you and your client may be excused. Have a great day, okay? Bye-bye.
Likewise, Your Honor. Thank you.
All right, bye.
Number 2, Mr. Jorge Munoz with his client Cesar Chapa. It's to be placed on PTD.
All right, let's see here. Mr. Jorge Munoz.
Good morning, Judge.
There he is with Cesar Ruben Chapa, right?
Yes, Judge, that's correct, Judge.
And where is Cesar
Right here.
Ruben Chapa?
He needs
Oh,
to
there he is
unmute.
right there. He needs to unmute. All right, can you hear me, Mr. Chapa?
Sí, lo escucho. Judge, he's a Spanish
Yes, I can
speaker.
hear
I
you.
apologize.
Okay, it'll be.
Levanta tu mano derecha, Cesar.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
¿Juras que el testimonio que vas a dar es la verdad, solamente la verdad y nada más que la verdad?
Sí, juro.
Yes, I swear.
And
Puedes
you,
bajar tu
can, and
mano.
you can put your hand down. All right, it'll be a PTD plea, right, Mr. Munoz?
Yes, Judge.
CR 1911 114D, Cesar Ruben Chapa, your charge here is a DWI case, Class A misdemeanor. It carries a potential penalty of up to a year in jail and not more than a $4,000 fine on conviction. You understand that?
César, en el caso tuyo, SR 19-11114D, el estado de Texas contra César Rubén Chapa. Te acusan de una clase A. Bajo la ley es no más de una multa de $4,000 y no más de un año en la cárcel. La pregunta del juez es, ¿comprendes eso? ¿Sí o no?
Sí.
Yes.
You understand that you're entitled to a jury trial, you're entitled to an appeal, and that you weighed those two rights?
¿Comprendes tú que tú tienes el derecho de apelar y también tienes el derecho de que un jurado oiga tu caso? ¿Es correcto que has rechazado esos dos derechos?
Sí.
Yes.
Have you ever been declared mentally incompetent?
¿Alguna vez te han declarado que estés mentalmente incompetente?
No.
No.
You understand that the court does not have to follow the recommendation when you give a plea?
¿Comprendes tú que la corte no tiene que seguir la recomendación del fiscal después de que tú te declares culpable?
Sí.
Yes.
You understand that if you're not a U.S. citizen, that you plead guilty in your case may result in deportation, exclusion from admission to this country, or the denial under federal law?
¿Comprendes tú que si te declaras culpable y no eres ciudadano de este país, eso puede resultar en deportación, exclusión o que tienen que entrar a este país bajo leyes federales? ¿Comprendes eso, sí o no?
Sí.
Yes.
And I meant the denial of admission under federal law. Okay, and how do you plead, sir? Guilty or not
¿Y
guilty?
cómo te declaras? ¿Culpable o no culpable?
Sí, culpable.
Guilty.
All right. Are you pleading guilty freely and voluntarily?
¿Y te estás declarando culpable libre y voluntariamente?
Sí.
Yes.
Okay. Mr. Munoz?
Judge,
Yes, Judge.
oh, sorry.
I'm sorry,
State-
evidence. Yeah.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification, defendant right of appeal as Exhibit 2, waiver of Article 39.14, disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4, PT pack as Exhibit 5. State would also request defense counsel to stipulate in the venue and jurisdiction of this honorable court, and to also stipulate that evidence has been filed sufficient to culpably plead guilty.
No objection, Judge, so stipulated.
And without objection, so admitted. However, at this time, the court will withhold any finding of guilt or innocence and will suspend any judgment in this matter and will now turn to the PTD packet or program here. All we ask here, Mr. Chapa, is follow the terms and conditions of this program. And hopefully sometime in the future, we can dismiss this case. Okay, sir?
César, lo que va a pasar en tu caso es la corte ha aceptado tu declaración. Tú vas a estar en un programa. Tienes que regresar el día 7 de diciembre a las 9 de la mañana, donde el oficial le va a dar un reporte a la corte de si has cumplido con todas las condiciones que tienes que cumplir. Mientras tú no te metas en problemas, cumplas con las condiciones, pagues lo que tienes que pagar y te reportes como debes de reportarte, entonces este caso se van a retirar los cargos. ¿Ok? Pero tienes tú que cumplir
Sometime
con
in the
todo
future,
eso
okay?
en el futuro.
Yeah.
¿Ok?
So for right now, it will be set for December 7th, 9 a.m.
So, por ahorita tienes
Status
una
hearing.
fecha de regresar el día 7 de diciembre a las 9 de la mañana.
So tengo que ir a...
Quédate en contacto con tu abogado y él te va a explicar.
Ok, perfecto.
Okay. All right. Thank you, sir. Good luck with your program here. Okay, sir?
Suerte. Te puedes
Thank you,
retirar.
Judge.
Gracias.
All right. You're
That's all I have this morning, Judge. Maybe excuse my client.
Yes, sir, Mr. Munoz. You may be excused. Thank you, sir.
Okay, Mr. Victor Jaramillo has Alejandro Salinas. He's got 2 cases, 1 plea and 1 possible dismissal. Victim, Alan Salinas is on the screen.
The number?
Number 6 and number 7.
6 and
I
7.
don't know if you want to take care of that one first.
Mr. Victor Jaramillo. Here we go.
Yes, Your Honor, that's
We-
correct.
Okay, we're gonna hear some testimony, right, State?
Yes, Judge, on one of them, Judge, yes.
Okay. So which is the one we're gonna hear testimony? So I can. Oh, number 7. Okay, we got it. All right. CR 21-13-696D, Alejandro Salinas. And there he is. And then we have who's the witness? Is it Alan Salinas?
Yes, Judge. And he's a minor, so his mom will be appearing.
So the mom will be testifying. Okay. Okay. Can you all please unmute? Mr. Alejandro and Alan, please unmute. All right, there you go. Thank you very much. So, okay. So then the mother's name, what's your name, ma'am?
Yolanda Gutierrez.
Yolanda Gutierrez. All right. Should be testifying, right, Mr. Quinn?
Yes, Judge.
All right. Ms. Gutierrez, please raise your right hand. You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may put your hand down and listen carefully to the questions. Mr. Quinn?
Yes, Judge. Can you please state the full name of the victim for the record?
The victim is Alan Salinas.
Okay. What is the relationship with, of the victim to the defendant?
He's his son.
Okay.
His father and son.
Can you tell me what occurred on or about? Let me see.
My husband got in an argument with my mother. Her name is Yolanda Gutierrez too. And then my son got in. So they got in a physical fight with my husband and my
Okay.
mother.
Were there any violent acts involved?
I'm sorry, I didn't get that.
Were there any violent acts involved?
Acts?
Violent.
Oh, like it was pushing, throwing in, yes.
Did the defendant wrap his hand around the victim's neck and apply pressure?
I can't assure that because I was in the middle of the discussion and I wasn't able to see that.
Okay. Is there a history of violence in the relationship between the victim and the defendant?
No, there was no history.
And are you concerned about any future violent acts by the defendant?
No, not at this time anymore.
Okay. Did you fill out an affidavit of non-prosecution with the DA's office?
Yes, we did.
Okay. And did you fill it out on your own free will?
Yes, I did.
And nobody promised you anything or threatened you in any way to get you to sign the affidavit?
Oh, no.
Okay. And do you wish to drop the charges against the defendant?
Yes, I do.
And you do understand that by dropping the charges, this case cannot be reopened. Is that correct?
Yes, I do.
However, you do understand that if another incident was to occur, you could open a new case. Is that correct?
Yes.
Judge, if I may ask, with your permission, ma'am, may I speak with your son?
Yes, you can.
Okay. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. All right.
Okay. Do you wish to drop charges against the defendant?
Yes, I do.
And are you you wish nobody threaten you in any way or promise you anything to get you to drop the case?
No.
Okay, Judge. State passes the witness, Judge.
All right. Any questions, Mr. Jaramillo?
No, Your Honor.
All right. Thank you all for your testimony. Okay. And then on the other case, is going to be a plea?
Yes, Judge.
Correct, Your Honor.
All right. That'll be CR 21. Yeah. Yeah, Miss Yolanda and Alan, you can log off. Okay.
Well.
Oh, you need them?
No.
We don't need them anymore. Okay. All right. Thank you, ma'am. You're excused.
sir.
Thank you. Bye-bye.
Bye.
And then Mr. Alejandro Salinas, please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. CR 21-13-695D, Alejandro Salinas. Your charge in this case is assault class A misdemeanor. It carries a potential penalty of up to a year in jail and not more than a $4,000 fine upon conviction. You understand that?
Yes.
You understand that you're entitled to a jury trial. You're also entitled to an appeal. Did you waive those two rights?
The what?
You are entitled to a jury trial and you are also entitled to an appeal. Did you waive those two rights in writing?
Yes.
Have you ever been declared mentally incompetent?
No.
You understand that the court does not have to follow the recommendation when you give a plea?
Yes.
And what is your plea, sir? Guilty or not guilty?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes.
All right, state.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification of defendant right of appeal as Exhibit 2, waiver of Article 39.14 disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4. State would also request defense counsel to stipulate to the venue and jurisdiction of this honorable court. and to also stipulate that evidence has been filed sufficient to plead guilty.
No objection, Your Honor. We so agree and stipulate.
Without objection, so admitted. It will be the judgment of the court. The defendant is guilty as charged. In a recommendation state,
Yes, Judge, the state recommend $200 fine, court costs, 1 year Hidalgo County Jail, probate for 14 months, an anger management course, 20 commercial hours, open restitution to Yolanda Gutierrez, and the defendant to stay away from Yolanda Gutierrez. And Judge, just for the record, Judge, the defendant completed the anger management course as part of the case that we just heard earlier, and that will be suffice for this case also, Judge.
oh, okay, so it'll be already taken care of.
Yes,
Okay, and court will hereby waive the community hours. So the anger course it's already taken. Court will waive the community hours. It'll be the $200 plus court costs, 1 year in jail, probated for 14 months, and then open restitution.
Yes, Judge.
You have a date for open restitution?
I give it to Rachel.
It's May 11, 2022
May-
at 10.
May 11, 10 a.m.
Yes, sir.
Okay, May 11, 10 a.m. in case we have restitution. 2022. And okay. And then what's gonna happen to the case we just talked about earlier, the first one?
Yes, Judge, that will be dismissed, Judge.
Court will hereby dismiss CR 21-13-696D, State versus Alejandro Salinas. Case is hereby dismissed. All right, Mr. Jaramillo, any questions?
None, Your Honor. May we be not excused?
Yes, sir. We'll see you all in May 11th, 10 a.m., okay?
Understood, Your Honor.
Okay, Mr. Salinas, good luck with your probation, okay, sir?
All right.
All right, you're excused. Thank you. Bye-bye. Have a great day.
Next, number 8, Mr. Espinosa, Daniel Anguiano, I believe he is, defendant has an ISO.
Oh,
It's a compliance hearing.
okay, here we go. CR 22-02-222D, Daniel Anguiano.
Good morning, Your Honor. Daniel Almigano is in federal custody for the immigration issue. I think he has court set for, let me see here, April the 25th, if I'm not mistaken. On the
Okay, so he's under federal custody right now?
Yes, Your Honor.
Oh, okay. And once again, CR 22-02-222D, Daniel Anguiano. All right. What we're set for the compliance hearing?
Yes, Your Honor. We're set for the compliance hearing.
Okay, so there was no way he could have
Obtain the,
complied with the request because he's incarcerated, right, sir?
yes, Your Honor.
Okay, no action today then. And we have recent date. And if give me a recent date if you can.
He's gonna be deported.
If he's
Is he
deported,
gonna-
we're gonna lose. Well, the status hearing. That's what I'm trying to say here. You gonna do a status?
For June 14.
June 14th status. See what the name?
At 10 a.m.
10 a.m. Status June 14, 10 a.m.
That will be in person. And he also has number 5.
Oh, number 5 is good. Number 5. So you got that date, right, Mr. Espinosa? The status hearing?
June 14th.
Right, 10 a.m. And we're thinking, we're saying it's gonna be in person, right? Wow. Okay. Let's go to CR 21-05-417D, Roel Flores. I understand there's a motion to suppress that's on file. Now we need to set it for hearing. Is that what it is?
Did he file it?
Did you file it, Mr. Espinosa?
No, Your Honor. I was going to file later on today. I was just requesting maybe a 2-week reset so I can get the discovery from the state.
Okay, you want to set it, you want a status hearing or you want to you
May 11th, 10 a.m.
for the status hearing?
Yes.
Okay. May 11.
You know what? Let me do this.
Okay.
Let's do October. Rachel, what is the October next year?
Okay.
October
pre-trial.
12, 2023 at 9.
If he feels that he wants to set it for MTS and to call the court and we'll set
Right,
it for MTS.
right. Okay, it'll be a pretrial
We'll
date
just
then,
hold
right?
it in circles, yes.
Okay, Mr. Espinosa. It'll be a 10/12/2023 pretrial date at
9 a.m.
9 a.m. However, when you do file, if you decide to do an motion to suppress, File it, and as soon as you file it, let the court know.
Yes, Your Honor.
Okay.
We'll bump up the case.
And of course, we'll bump it up.
I have nothing
All right.
further.
All right. Thank you very much. You're excused. Have a great day. Bye-bye.
I have number 3, Mr. Oxford for Terry Canales.
Number 3,
I
okay.
don't see his client.
Well,
His
let's
client
see
needs to be present.
what's going on here.
It's a motion to remove interlock.
Mr. Oxford, can you hear me?
Hear you, Judge.
All right. Good morning, sir. I think it's still a morning. Yes, it is. CR 20-2-994D, Gerardo Flores Aguirre. Is he there by any chance with you?
I don't believe he's here at our office, Judge.
Okay. He's not in the waiting room either. And it's a what? A motion to remove?
Yes, Judge. We're asking to remove the interlock device. He's had it since 2020, I understand that if he were to apply, can you hear me? Okay, Judge. I've been having issues.
Yes.
Okay.
I can hear it.
Yeah, we've been having issues on our end for some reason. He has had the device for 2 years. We have explained to him that if he's going to be asking to be placed on pretrial diversion, that it's going to be a mandatory device.
Condition.
A mandatory condition, that's correct, Judge. But it's not necessarily mandatory if we are applying for, or if we're asking for deferred adjudication.
Okay, I think you froze, Mr. Oxford. I knew something was gonna happen.
Are you?
Okay, you froze there for a while. You froze there for a while there. That if he asks for deferred adjudication, it
Mandatory, it's a class B misdemeanor.
Okay.
So I don't believe it's mandatory.
Okay. Okay, I have a question, Mr. Oxford. Is this his first DWI case or he's got a prior?
Judge, I'm showing that he's got it's a class B misdemeanor. If my understanding, if my understanding of the law is correct, if it was a second, it would be a class A, which I'm showing that it's a class B.
Judge, if I may.
Yes, sir, Mr. Witt.
Judge, the state, we opposed to the removal device first because when the officer responds to this case, the defendant's car was stranded in a ditch. And also, this is his second DWI arrest, Judge. And the statute reads that if they require a device as a condition of bond, if they're charged with a DWI, subsequent DWI on after September 2019. And so the statute says charged, it means that the previous case, he has a previous DWI from 1990. So this is a DWI second arrest. That's the reason why it's still a class B, and it still say as a class DWI, not a DWI second, right. But it's still a second DWI arrest. And statute required that if it occurred after September 2019, then as a condition of bond, a device is required, Judge.
Okay, and this is Article 17.441?
Yes, Judge.
Article 17.441, conditions requiring motor vehicle ignition interlock. Are you familiar with that one, Mr. Oscar?
I am not, Judge.
Okay, I have it here before me, but you need to look it up or get a copy from the state on Article 17.441, and I think it's there. I think that's what it says here, that if you've been arrested for the second time, then it is required. Although it's a class B, you know.
I got to dismiss.
Yeah.
Pulled it up.
This the criminal code. Mr.
Yeah, and it does look to read that if he's just simply charged,
right.
And Mr. Aguirre was actually charged with a subsequent offense. Okay, I mean, I've made my pitch, Judge. I mean, I guess this may push him to
hurry up and take his next move.
Correct.
So then the motion to remove the interlock is hereby denied. Okay, sir.
Very well, Judge. Mike, and would you send me a recommendation on this case and see if we can?
Sure, if you could email me, so I can have have it for my record so I could, review and also, have send a paper trail of my recommendation.
Okay, sounds good. I'll email you.
All right. Thanks.
All right, gentlemen. Thank you very
Judge.
much. Thank you very much, Mr. Oxford. Your excuse. Have a good day.
Thank you, Judge.
Yes, sir. Bye-bye.
I have these three people here. I don't know who they are.
Okay,
let's see
so
who they are.
let's not, okay, Mr. Gwynn's still with us, right?
Yes, he's still
All
there.
right, let's see, okay. Okay,
Still breathing.
still reading there. There's Sarah Miller.
So I don't know what.
She's connecting. Sarah Miller. I'm sure she's done one of the cases.
I look for those names.
Miss Miller, can you hear me?
Yes.
All right, which is your case, ma'am?
It's for Sadie Guerrero Namazaya.
Yeah, that case was already taken care of.
We took it, was that a civil case or
Yeah,
what?
that was
Oh, yeah, we heard, I remember the name of.
I'm trying to get a transfer to El Paso.
Yes,
was
it
the
was
only
granted.
thing.
Oh, yeah, that was a motion to transfer.
That was granted.
Mhm.
The case to El Paso?
Yes.
Yes, that got granted.
Oh, okay. This morning or?
Yeah, this morning.
Oh, okay, perfect. Thank you.
All right, thank you, ma'am. Bye-bye.
Okay, bye-bye.
Okay, next. Let's see, is it Oscar Dimas?
Who connects first?
Okay, let's see. Zulema Aguirre. You need to unmute. Zulema Aguirre. How about Mr. Dimas? You need to unmute, Mr. Dimas.
Gerardo Aguirre.
Okay, Mr. Gerardo Aguirre.
Sí.
Which is the one? Gerardo Aguirre. Right here. Number 3. What happened to this one?
Which is the one?
The one
Yeah,
that did not. Okay.
Señor, el caso de usted ya se llamó, como usted no está bajo su nombre, la corte no pudo identificarlo. Es importante de que cuando usted tiene Zoom, se tiene que identificar con el nombre de usted. El juez ya llamó este caso, lo acaba de llamar ahorita.
Con Mr. Oxford.
Con el señor Oxford, que está aquí por Cherry Canales, y ahorita no le va a conceder a que le quiten el aparato, porque este es su segundo DWI, y por ley es mandatorio. Es importante de que hable con su abogado, a ver si puede llegar a un acuerdo para que arreglen este caso, y así, lo más pronto que pueda arreglar el caso, entonces se quita ya ese aparato.
Okay.
Correcto.
Okay.
Háblele a Mr. Oxford, por favor, ¿ok?
Está bien.
All right, thank you, sir.
Gracias.
Bye-bye.
Ajá, pase buen día.
Bye-bye.
Igual. Bye.
Gracias por su paciencia.
Who's next now? Dimas needs to unmute.
Hello?
Hello, Mr. Dimas. Which is your case?
No, this is I'm using my my supervisor. This is Roel Flores.
Your name is Ruben Flores?
That was not a good
Yes,
idea,
Your Honor.
Ruben.
Let me
Not
see.
a good idea, Ruben.
That was Roel Flores?
No.
That's Roel Flores?
Yes.
You're Roel Flores, right, sir?
Yes.
Okay. All right. Okay, Mr. Flores.
It's because my phone is not working properly.
Okay. So we understand now. We already took care of your case. We talked to Emmanuel Espinosa, your attorney, and he will be talking to you real soon.
Give him the reason date.
Yes,
No,
Your Honor.
but the recent date is way far away. So. Okay, Mr. Flores, we gave your attorney a reset date. It's way down yonder, way far away. However, if he files something earlier, we're going to hear him earlier, okay? But right now, there's a pretrial date for October the 12th, 2023 at 9 a.m.
For next year.
Yeah, 10/12/2023, which is next year at 9 a.m. That's the pretrial date. But if you and your attorney talk and you decide to file something else, we're going to hear it a little earlier. Like real soon, okay?
Yes.
All right,
Yes.
Mr. Roel Flores, DBA Oscar Dimas. Your excuse, okay, sir?
Thank you, Your Honor. Thank you.
Thank you. All right, bye-bye. Have a good day.
You too.
Bye-bye. You too. Okay, that's it right now? Okay, we're still adjourning.